last night, blacked out, but it's price pickets. Yeah. Like, it's too early.
Hi, welcome everyone. I will officially call this meeting of the Mineland Reclamation Board on December 17th to order. And we'll start with introducing the board present here and online, starting with Wendy.
Wendy Padilla, Deputy Executive Director for the Department of Natural Resources.
Jill Nielsen. Karen Stiglmeyer. And online we have a number of our board members. Maybe start with Nell.
Now we're in present.
And Doug.
Good morning. Good morning.
There's Allison. And Allie.
Good morning, Allison Tarrant.
Okay. Thank you all. And little intro of staff.
Yeah, I'm Chuck Coyman with the Attorney General's Office, Counsel of the Board.
Good morning, Michael Cunningham, Director of the Division of Reclamation, Mining and Safety.
Russ Bates, I'm the Minerals Program Director.
Jeff Gray is Program Director for the Inactive Mine Reclamation Program.
We don't always do that, I guess. Okay, we'll move right on to approval of the November minutes that we've all received. Are there any comments, questions on those minutes?
I move we approve the minutes.
Second. And we have a motion from Doug and second from Jill. Any other comments? Call the question. All in favor say aye.
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 Any opposed? Okay, unanimous approval. And then we have approval of continuances and withdrawals. There is one that we received, which is file M 1985-082. Questions or motion to approve continuances and withdrawals? Move to approve.
Second.
Okay, we have a motion and a second. All in favor say aye.
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 Any opposed? Okay, we'll move on to the Executive Director's Office and Division Director reports. Indeed.
Thank you. Well, welcome everyone. I just want to acknowledge today that in the Denver metro area, there may be power outages, or there will be power outages starting at 10 a.m. and maybe going to 6 p.m. because of potential high winds. And we just want everybody to stay safe as possible. I know some schools are closed. So just from the Department of Natural Resources, we have a lot of backup in terms of our technology. So we will keep our fingers crossed. How about that? Mountain pine beetle. You may have heard in the news that the governor signed an executive order on Monday this year, aerial detection of forest health by the U.S. Forest Service and the Colorado State Forest Service highlighted an outbreak of mountain pine beetle along the northern Front Range, really from Colorado Springs north, getting worse over the next 10 years. It's projected to be, and those effects can compound over time and create higher wildfire risk, especially where we have high population levels on the Front Range. And so the task force created by the executive order will come together to make recommendations on how to use our resources most effectively to have a coordinated response among local, state, federal agencies, timber market, as well as even looking at insurance markets. And we'll be putting together educational materials, outreach, such as a website for the task force and more information to come on that. our Colorado State Wildfire Action Program just awarded 24 projects for workforce development. And what this does is trains the next generation on wildfire mitigation practices such as, using chainsaws, for example, and Colorado Youth Corps work with mitigation projects. Around water, on November 19th, the Colorado Water Conservation Board voted to advance Shoshone water rights for permanent in-stream flow protection. And on November 20th, Colorado River District and co-applicants filed the water court application to begin the change of water rights request. And what that application will seek to do is to add in-stream flow use to Shoshone water rights while still allowing for the hydropower production. And then just a reminder for everybody, there's a website called coloradoriver.com. It is run by DNR, but that is the place that has all the latest information about Colorado River negotiations. No update right now, but we should have an update by mid-January or so. And then finally, one other note of interest, there is a potential oil and gas development near Aurora Reservoir called Sunlight Long. The ECMC Commission has stayed a decision on that pending further analysis. They were supposed to make a decision recently, but that has been delayed pending further analysis. So other than that, I don't have any updates, but if you have any questions for me, I'll be happy to take them.
There's always a lot going on. Division Director report.
Thank you. Good morning, Madam Chair, members of the board. Michael Cunningham with the Division Director's Report. I'd like to start off with an introduction. Maybe in October, I announced to the board that we had filled our Finance Director position. I'd like to introduce the board to Pafanzi Dessou. Pafanzi has a bachelor's degree in marketing and financial management, a bachelor's degree in accounting, and a master's degree in accounting and finance from Regis University. She has extensive state experience, having previously worked for the Office of Information Technology, the Department of Personnel and Administration, and the Colorado Department of Labor and Employment. Pafanzi joined our staff in 2020 and was previously the Inactive Mine Reclamation Program's grants officer. And we are very thrilled to have Pafanzi in this new position. And so just wanted to make that introduction to the board. Moving on, 'tis the season for budget and legislative items. The division has a hearing scheduled before the Joint Budget Committee on January 8th to discuss the proposed budget and update and answer questions from the committee. On the legislative front, I'm excited to inform the board that the division will be pursuing legislation next year related to underground injection control wells. Just a little bit of background on this. Senate Bill 2316 directed the Energy Carbon Management Commission to conduct a study looking at whether Colorado should pursue full primacy for all subsurface injection classes within EPA's underground injection control program. As of this year, just for reference, over half of the states, 34 of them, have been granted primacy for at least classes 1 through 5, and 5 states have been granted full primacy for all UIC well classes. Those states include North Dakota, Wyoming, Louisiana, West Virginia, and Texas. Colorado currently has primacy over class 2 and class 6 wells. With this legislation, Colorado would assume primacy for class 1, 3, 4, and 5 wells. So the way that this would work, this is legislation that's being run in concert with ECMC. If the legislation passes, oversight responsibilities would be split between ECMC and DRMS, with DRMS assuming responsibility for all class 3 wells. For additional reference, within Colorado, we do have some class 3 wells that we regulate out of the West Slope. We have actually just one operator, Natural Soda, and they've got underground injection control wells for the extraction of noccolite, so baking soda. And so we've got experience in working with that area. So if we are successful in gaining primacy, the EPA would transition from a direct implementation role to an oversight role. And then we would have to set up this program and adopt regulations, which would need to be as stringent as the EPA's. As we move forward in this process, we're not anticipating diverging much from what the EPA currently has. But we're currently working through the stakeholder process right now. And I think some of the advantages we see are that currently DRMS has a role in these mine sites, and we have to have a permit in place. There's also a permit from the EPA. So this sometimes can create duplicative authority, complications in ongoing regulations. And further, we feel this would insulate the state from changes at the federal level, including staff availability. And so last thing I'll note on that is the sponsors on the bill are Senator Simpson, Senator Hendrickson, Representative Pascal, and Representative Smith. And I will share a fact sheet with the board just with some details on that, but I'll keep everybody up to date as we move through that process. And last thing I'll note here, we have an agenda item today for further discussions on the Mine Subsidence Protection Program. The last few presentations that we've had before the board have been more educational in nature to help familiarize the board with various aspects of the program. For today's item, we'll move into some of staff's recommendations on ways to improve and strengthen the Mine Subsidence Protection Program. But I just really want to thank the board for your thoughtful engagement in these discussions. We have a lot of work to do over the coming year, but I'm confident that with the board's direction, we'll find opportunities to ensure this program remains of value for the residents that live in these historically coal-mined areas. And finally, just wish the board a very Merry Christmas and Happy New Year. We've got holidays just around the season. I hope everyone has a chance to unwind with friends and family, and excited and looking forward to a busy 2026. So thank you, and I'm happy to answer any questions from the board.
Questions? Thank you. We look forward to learning more. Okay, we'll move on to the consent agenda, and there are none. So we'll move on to enforcement hearing file number M-2013-066. Arboles Sand and Stone LLC. And I think we have the presenters, and before we get started, please raise your hand and swear to tell the truth.
Yes. Yes.
Okay, thank you.
Yes.
Ready.
Good morning. My name is Chris Girardi. I'll be representing the division in this enforcement action. This hearing is for the Lob Lolly Pit, permit number M-2013-066. Is permitted to and operated by Arboles Sand and Stone LLC. Just a quick overview of the site again. This is a construction materials permit encompassing 161.9 acres for sand and gravel. Post mine land use is industrial commercial, and the existing financial warranty is our bond is $98,585. And this is within Archuleta County, approximately 5 miles north of Arboles, Colorado. These two pictures show kind of the on the left hand side, this is the north permit area, and then on the other side, this is the south permit area, which is in final reclamation. So again, we convened back in November for the first hearing for this enforcement action. Just as a refresher, on September 24th, The community banks of Colorado notified the division that the letter of credit, so the financial warranty, will expire on December 31st of this year, pursuant to Rule 4.1, Parent 7, and CRS 34-32.5-117, Parent 6, Parent A. A financial warranty must be maintained in good standing for the entire life of the permit. And this is the document that was submitted to the division from Community Banks of Colorado. And this is all very duplicative, but just kind of, again, talking about the notice from the bank. And then October 9th, the division issued our RTB, reason to believe violation exists letter, and notice of the hearing to the operator. And then we held the first board hearing on November 12th. On November 19th, the board issued the findings of fact, conclusions of law and order, and found the financial warranty subject to forfeiture. Part of that board order, violation MV 2025-016. The board found the operator in violation of CRS 34-32.5-117, Parent 6, Parent A, for failure to maintain the financial warranty in good standing for the entire life of the permit. The board found the financial warranty subject to forfeiture for failure to cure a default under a performance warranty, despite given written notice of the default pursuant to CRS 34-32.5-118, Parent 1, Parent B. The board order also issued a cease and desist order preventing any further mining activities except those approved by the division. The board imposed a corrective action that by December 16th, the operator would submit either a replacement financial warranty or submit evidence to the division that the current financial warranty is in good standing. And the board also issued a civil penalty for 34 days of violation at $100 per day, for a total civil penalty of $3,400, with all suspended if the operator complies with the corrective action. So again, this is part 2 for this 2 hearing process. Pursuant to CRS 34-32.5-118, Parent 3, at this hearing, this is for consideration of actual financial the forfeiture of the financial warranty, and the board would confirm its determination that the financial warranty should be forfeited and issue a written finding of facts and conclusion of law to support its decision. And again, when the division sent the RTB letter in October, the division provided the operator and the financial warrantor with the notice that if the board finds the financial warranty subject to forfeiture, the consideration of the final forfeiture would be of the financial warranty would be at this December hearing. And since that November 2025 board hearing and that the board order as well, the operator has not complied with the corrective action, as the division has not received a replacement financial warranty or evidence that the current financial warranty is in good standing. The operator did submit an irrevocable letter of credit to the division on December 11th. That document was inadequate. I guess regarding that, pursuant to Rule 4.7, Parent 1, the irrevocable letter of credit should be executed on the issuing bank's letterhead using language provided by the division. And pursuant to CRS 34-32.5-117, Parent A, financial warranty should be in a form as the board may prescribe and may be provided by the operator, by a third party, or by any combination of persons or entities. So staff recommendations. Staff recommends the board confirm its decision to forfeit the financial warranty pursuant to CRS 34-32.5-118, Parent 3, Parent A. And staff recommends the board issue findings of fact and conclusions of law and order to support its decision, and issue an order directing the affected financial warrantor to immediately deliver to the board all amount warranted by the applicable financial warranty pursuant to CRS 34-32.5-118, Parent 3, Parent B. Staff also recommends revoking permit number M2013-066 pursuant to CRS 34-32.5-124, Parent 6A. Questions?
Madam Chair, this is Russ Mange for the division. I just need to add something for the record. late yesterday afternoon, the board did submit, the bank did submit a proposed amendments to their incorrect financial warranty paperwork. And all it did is correct a couple of clerical errors, but it did not remove language and stuff that they had added in to the form and stuff. And as noted and stuff, it has to be a board approved language. So I rejected that and I sent them the form and told them they had until 9 o'clock today and stuff to submit the correct form and signed and stuff and that. And if that was the case and stuff, then we could resolve this. And as of right now, I have not received anything. So that's just for the record. Thank you. And we do have a representative and stuff in that for the operator and stuff that Nathan Martin. Nathan, I don't know if you wanted to say anything.
Yes, I would, with the board's approval and with that of the division, like to identify a number of things. Again, as Russ pointed out, for the record, I do identify, need to identify myself. I'm the engineer for Arborlee Sand and Stone, and I've been involved in this mining operation since 2007. The Wrights, who own Arborlee Sand and Stone, are not just clients, but they are friends, long-term friends. And I do thank the board and the division for all of the assistance that they have tried to help for the extension. In particular, the recommendation was made by a board member in the last meeting that we try to find another bank or bonding company. We were unable to find anyone who could guarantee that they would provide a new financial warranty by today. And therefore, we had no choice but to believe the bank's promises of correcting the situation. The Wrights and I do fully understand that you must follow the statutes, that you must protect the interests of the state, and we appreciate the effort. Especially, we'd like to thank those that provided assistance and help, including Sarah and Russ and Chris. They have gone far more than the second mile in doing that. Steve and Joyce did not find out about the cancellation until the division, in fact, itself notified them. The bank did not tell them. We had to go to the bank to find out. People in the local bank branches in Archuleta and La Plata counties, including a lady named Nikita and a Michael Minga, have worked very hard, and they have been completely unable to explain to the hires up in Community Banks of Colorado or the holding company the importance of this and the procedure that needed to be followed. As Russ pointed out, he had provided forms to them. We had provided those forms to them weeks ago, explained to them, cited the references and everything else. We've spent long hours working with them and trying to go through other bank channels to get their hires up to follow their instructions. They did that once before when they first issued the financial warranty years ago, the one that was canceled without reason. Nobody in the bank has been able to tell us why that was done. Again, Steve and Joyce have begun filing complaints with the State Banking Commission, with the FDIC, and I am certain that they will pursue legal action against the bank for what the bank has done to them, because this likely will drive them into bankruptcy, especially with the need to impose the added fine. And again, we understand that that is necessary, that you all must follow what is done by the state regulations and by the statute. But we would like to point out that this is a very sad day. Also would like to notify that that excavation, the actual mining, is pretty much completed on the north end as well as on the south zone. And the reclamation, especially repairs from the flood back in November, just last month, are underway, and we're trying to get those areas cleaned up. Obviously, this will make an impact because there's still a lot of work that needs to be done. There's equipment that we need to make sure can be removed that belongs to a contractor of Arborlee Sand and Stone and not to Arborlee Sand and Stone itself. Again, we had planned to ask for full release of the remainder of the south unit this spring and for partial release pending revegetation of the north end also this spring in order to accomplish all the things that Arborlee Sand and Stone had committed to in the original permit. That is, again, what I wanted to make clear for the record, that we understand, we know that this is indeed a very sad day. I would like to ask, with your permission, a couple of questions as far as how this can be proceeded. Can the board allow reclamation work that's already underway to proceed, at least on a limited basis, under the direction of the state? Can the current contractor for Arborlee Sand and Stone, which is already doing the reclamation work and had been doing the mining for them, may they operate under state control? And if necessary, may they submit a proposal to continue the reclamation under DRMS supervision? And then a final request, and I fully understand that I cannot expect anything that is not legally allowed, but is it possible that the board will permit DRMS personnel to provide affidavits or to provide testimony related to any legal action by Arborlee Sand and Stone and by the rights against Community Banks of Colorado? I realize that's probably an unusual request, but the bank has frankly dealt itself a incredible blow. It's ironic that we discovered just yesterday that Community Banks of Colorado was supposedly rated as one of the best 10 banks in the entire nation as far as providing customer service. We find that obviously to be incredible. They knew for months in advance. They refused to take action. When they did, they refused to follow the very clear instructions that Sarah, that Russ, and we all provided as far as following the law. And as a result, they have dealt in a very severe blow to the rights. I am open for any questions, and I do thank you for the time you've given me.
Questions? I have a question regarding that request. Would it, no, would that not be a good thing to allow them to continue reclamation?
Good Russ means for the division, usually in stuff in the cases, we ask that for a cease and desist order, just simply because we know what the conditions and stuff are there now. And this is turned over to the inactive mines program and stuff for reclamation. That's what they're looking at and stuff is our inspection reports and other issues and stuff there. They do have some flood impact issues and I don't know whether Scott wants to chime in and stuff here or not, but certainly any kind of flood mitigation work and stuff and that is, it could be considered as stuff outside the mining operation itself and stuff like that. We don't want to have any further impacts from the flooding and stuff on their personal property. So I think it's stuff, if we were to get a letter and stuff stating that they were doing that and stuff and that for flood mitigation and that, and only that and stuff and that, then we would support that. The other part of it and stuff, I know Scott will want to chime in and stuff here and stuff and that as the request and stuff for affidavits and those kind of things. But that's a legal process and we have channels and stuff to deal with those kind of things. They don't happen very often, but there is a process and stuff there, and that would have to come through the courts and those kind of things there. One thing I would like to do and stuff and that is if there's a civil, is there still a civil penalty out there? Due to the circumstances and stuff and that, possibly could the board and stuff would just waive all the civil penalties based on the efforts and stuff of the operator, and that the division doesn't see, it seems kind of duplicate punitive, if you will, and stuff there. So think it'd be appropriate and stuff for the board to waive the civil penalties. But
Has this been a good operator?
yes,
And so failure to make things happen falls on the operator, but it's very convoluted because of the bank. Is that really the catalyst here, or is there?
yes, there was, you know, there was other options and stuff available, obviously, and they did try to pursue some of that. But a lot of this came back and as miscommunications and with and the bank and stuff, not wanting to use our forms, but adding in additional language and stuff and that changed significantly protections and stuff that the board has and stuff in our documents and stuff that are that you know embedded and stuff by the Attorney General's office and everything else. And it just wasn't acceptable.
Do you believe that they have a little bit extra time that they would get it if they didn't get it by 9 o'clock today, or is the bank
Because-
just digging its heels in?
Yeah, because the letter of credit expires on the 31st. We have to protect the interest and stuff there. If it expires and we don't, and the board doesn't take action, then you put yourself in peril and stuff and not being able to draw on those funds.
Mr. Baker, here, I have a question. Currently, all the paperwork's in place and it's proper for this year, correct?
To the end of the year,
I'm not.
Can you clarify?
the guarantee is valid.
It's valid, it's valid. So this, we haven't changed our requirements between this year and last year, have we? In terms of the form or the paperwork or any of that, we haven't changed anything. The bank has signed on to the proper paperwork for this year. They're just balking on signing on to the proper paperwork for next year, correct?
The Russ means for the division, that's correct and stuff. The current letter of credit and stuff for that is good until the 31st.
Wow.
And be clear and stuff that we have not changed the forms and stuff for most of our bonding documents in the last, I think, 10 or 15 years. They've been pretty standard and stuff through the entire time. So, but yeah, there has not been any changes and stuff for that in the near past.
Well,
Actually, Russ, I don't think the form has changed in 20 years.
That you're probably right. I was trying to be conservative.
Can we make this?
this is almost mystical as to why the bank won't sign on to what they have previously agreed to sign on to. This is hard to understand, and I do agree with you. I believe community banks is a pretty stand-up operation. They're not, they're not a flaky bank by any means, and they're highly rated. So it seems like it's almost clerical or a legal problem within the bank.
Sir, if I may, I agree, and I will point out that my own company, Wasteline, and associated companies have been doing business with Community Banks of Colorado for 20 years and have always gotten incredibly good service. There's something seriously wrong.
Yeah.
Their own people in Durango and Bayfield and even in Evans, where we have our operations, cannot figure out why they cannot explain to the people in Greenwood Village and back in Kansas City the very simple thing that exactly what you pointed out. It's no different than what they did years ago.
Wow.
They still can't even tell us why they sent the notice to the division that it was being terminated at the end of this month. They made Steve and Joyce go through an entire new set of credit checks and everything else, which ate up weeks. And then, even though we gave them specific forms, I even filled the form out, the state form out, mostly for them. The only thing they needed to insert was a date and a signature. And they refused to do that because they claimed it would create a second negotiable instrument.
Second to the letter of credit, that Second to the LLC.
Yes, to the LLC that they had issued, the incorrect one.
Yeah. Boy, this is really frustrating. I mean, it seems like the operator's bending over backwards, and it also seems like there's people at the bank that would like to get this done, but somewhere it's being shot. It's getting killed somewhere.
It does, and I wish we knew. I was hoping that we could get someone from the bank to actually explain, but they were not able to coordinate someone.
No, I understand why the bank doesn't want to expose themselves on this, but this is really frustrating. And like I said, I've had dealings with community banks for years. They're a stand-up company. This is not a fly-by-night bank. So there's some kind of a glitch here that we're not seeing it. I don't know where it is, but it needs to get corrected.
Yes, sir. But I don't know if you all have the authority to provide any more time at all, not and keep the best interest of the state.
Madam Chair,
Yes, now,
just to kind of clarify the process, listening to what Russ mentioned, about, being protective of the state, this feels like it probably needs some administrative guardrails, follow some process. It doesn't sound like we're going to figure out this whole mystery or the why behind it in time to sort of follow those things, but is the intent to sort of put some parameters administratively around this from what the board can do within its jurisdiction, not be terribly punitive, and then give these guys a little bit of time to figure out what's going on? Is that sort of what's sounding like the appropriate direction?
Madam Chair, may I speak? I'm the bond specialist. My name is Sarah Stevenson Ben.
yes, please.
Thank you. Good morning, everyone. If I lose you, I apologize. I'm in the area of the high winds, potential shut off. But I do want to say that from a bond specialist point of view, we have to serve this bank in time. So before December 31st, with this paperwork, before the bond expires via FedEx or certified mail. So if we give them any more time, there is my concern, especially with the holidays, that we get this served in time to call our bond. And I just want that noted.
So that is why the staff has an item to immediately deliver.
Correct.
Versus being on the 17th to the 31st, it takes 16 days to make sure that FedEx gets done.
Correct. And there's several different addresses here. And as everyone has mentioned, the bank has been difficult to work with. And my concern is, from administratively, I will be serving multiple addresses to make sure that this is served to the correct party at community banks, whether it's the Kansas City office, one of the local branches that initially provided the bond, just to kind of cover the state's all the bases to make sure that they are served. So it is, in my perspective, a time crunch. If we are going to call this bond, they are unbonded as of January 1st. I have to have them served via mail by then.
Thank you.
Thank you.
Thank you, Sarah.
I do think we have an option to waive the civil penalties, and that makes sense to me. But the rest of it seems clear that we need to follow what the law states. And there's been a lot of work on this, but we don't have other options as far as I can tell.
Well, I have a few more questions here. Clearly, this state has to be protected. So I understand completely why we need to call the bond. Because we have a bank that is stalling, whether, you know, on purpose or whatever, it doesn't matter why, but they're stalling and they cannot be allowed to stall and let the bond expire. So,
Amen.
yeah, so I believe that we're wise to call the bond, but the question that I have is, can we allow the operator to operate for a reasonable period of time without a bond? Or can we accept the fact that we have pulled the bond and we can hold that money in suspension and allow him to operate for a reasonable period of time? Because if now that I'm better understanding this, this bank can't get out of their own way in this situation. And I don't think we can expect a miracle between now and the 31st of the month. So it's probably not going to happen. Pulling the bond just might get their attention, but I doubt it. I doubt that.
When you
So
pull the bond, you pull the permit.
Yeah. Russ means for the division, and Bill, to answer your question, if we, what we're asking for today is revocation of the permit, and we have to have the revocation of the permit in order to forfeit the bond. That's the process and stuff there. If you were to allow them to do activities after that, then by law, they're mining without a permit because they don't have a bond, they don't have anything and stuff there. They don't have a legitimate permit issued by this board. So it would create a different situation where where the operator and stuff is in violation for mining without a permit.
but Russell,
Unfortunately, we're kind of handcuffed in that. That's,
and I get that, but Russell, if we pull the bond and then the operator would reapply for a
well,
permit.
that is an option and stuff that Mr. Barton will tell you and stuff. That one of the things and stuff that I did point out and stuff is that because these are a good operator and that one of the options and stuff is to go ahead. We have to move forward on the process. However, if the rights and stuff decided and stuff to re-permit, they could certainly come in, and the division and stuff and that would work with them and stuff to try to get that permit and stuff put back in place under a brand new permit with a different bond, with a different bonding scheme or something like that. So they do have that option in that. So but there again and stuff and that's a business decision and stuff by the rights and stuff that we can't control.
Would they have an opportunity to operate during that time period that they are reapplying and trying to get a new bond? Could we give them the opportunity to operate?
Yeah, just maybe offer some regulatory guidance here. Under 3432.5 parent 6, it says upon a determination after a hearing that a violation of a permit provision has occurred, the board may suspend, modify, or revoke such permit. Subpart B then goes on to say, if the board suspends or revokes the permit of an operator, such operator may continue mining operations only for the purpose of bringing such operations into satisfactory compliance with the provisions of such operator's permit. Once such operations are completed to the satisfaction of the board may reinstate such permit. So thinking here, is it possible for them, based on that statute, we'll revoke the permit and we can call the bond, and if they can work towards the bank getting us the letter of credit, on the proper form, we can then reinstate the permit.
Problem with that, there's a problem with that.
If I could jump in, Jeff Fugate here, attorney for the division. There are some limits to how creative we can be in circumstances like this. Obviously, the divisions has been trying to be very flexible and accommodating to not end up with a revoked permit and forfeit bond. As you saw in the presentation, this process started in September. There's been 2+ months of working with the operator and the operator working with this bank to secure the bond or other banks to secure a new bond, and that did not happen. In very limited factual circumstances has the division pursued any kind of suspension of a permit or a revoking a permit with an option to reinstate. In this instance, at no point in time, I think, can the board of the division allow somebody to continue to operate at a site that is not bonded and certainly that has a revoked permit. There's exposure to the state there. This is fairly limited work, but there's still a chance that they may do some work that goes either outside the permit boundary or creates some additional liability that is unaccounted for. And now we've got an unbonded site without a permit or an operator. I think in most circumstances, that's the situation we're trying to avoid, is having no money to cover a liability where there's work continuing to occur at a site. So I guess I would encourage exploring some of these creative ideas, but in the end, I think the proposal from the division to revoke and forfeit is proper here because we are out of time, and by the end of this month, there will be no bond tied to this liability.
Madam Chair, may I speak for a moment?
Sure.
I would have to defer obviously to Scott and to Sarah on this, but when the bond is called, when the $98,600 is called, does that money go into the treasurer's office? Does that money go into a DRMS account? That's actual, well, I assume probably not cash money, but let's just say it was. Would it be possible for that to be held by DRMS or by the treasurer as a cash bond in order to allow the reinstatement or to allow the reinstatement of the revoked bond? I understand that, I'm sorry, the revoked permit. I understand the permit must be revoked in order to trigger the call of the money. But once that money is in the state's hands, would that then serve as a financial warranty to allow that to be reactivated?
If I could respond to that, maybe Sarah can as well. I believe once the funds are forfeited, they're held by Treasury. They're not in the form of a financial warranty as defined in our active rules. They're no longer associated with this operator. They are money for the benefit of the state to conduct the reclamation work.
That's correct.
Yeah, so there's nothing that ties that money to this operator. It's tied to this liability. It's earmarked to be spent here, but it's no longer associated with the operator.
Jeff, just correct me if I'm wrong, but my understanding is that once that money is used to do the reclamation, if there's like overage, that goes back to the operator.
It goes back to the financial warrantor.
To the financial warrantor.
Right. So if the state goes out and conducts reclamation, it is less than the $98,000 currently held. That excess is returned to the warrantor. I don't know if that will happen here. And again, that circumstance is years down the road.
And kind of in the interim, you know, if this order is issued, served like today, let's say by some miracle, Christmas miracle on the 21st, they get a letter of credit. What's the options there? I mean, it's kind of hard.
Again, it depends on how creative you all want to be. I mean, we will have a board order for revocation of forfeiture. If somehow a bond is in place before the 31st, before it is terminated, we sought to abide by that board order, short of some kind of emergency hearing or termination, vacature of that order. I think we're kind of on the path here for revocation of forfeiture.
Yeah. Would that make reinstatement a lot easier? Like,
certainly.
Like, let's say there's board issues the order, but turns out that like I said, Christmas Miracle Bank gets it together. We've got coverage before the 31st. They have a letter of credit. There's no gap. Yeah, I don't know. It's, we still got the process rolling to fourth.
Sure, and I mean, it gets somewhat speculative and what may or may not happen. I mean, if there is a circumstance where this is all remedied before the 31st, then certainly the operators could consider some form of petition for reconsideration with the board in January. The money will be revoked, but not, obviously not have been spent. So there are some options that we could consider, but I don't know that we spend time kind of working through those here.
Yeah.
I think if something is to occur, division's been very open to work with Mr. Martin and the operator, so we can tackle those if something does in fact turn in their favor.
Yeah. The best practice here is to proceed with the statutory outline, protect the state, and then if, you know, something really positive happens, division can always come back before the board next month. Division operator can always come back for the board next month with a different proposal.
Correct.
And we can figure out what to do in the interim, should that happen, but. As Jeff said, there's just sort of given the timeline, given the potential exposure for the state and the statutory process, we just don't have, there's not a rabbit that we can pull out of the hat. Kind of given the, you know, very few days we have, very few business days that we have before this this warranty goes away and the state's left to hold the bag.
So the staff recommendations as is would allow for if the rabbit did pop its head out to be reconsidered. You know, what kind of bothers me is this immediately deliver versus make sure this is all said and done.
I've never done it before. I'll say that. So, yeah, we
Yeah.
get the money and stuff and it comes into the state treasury. I'm not sure what kind of a rabbit hole that would be and stuff to try to extricate that money back out, put it back into a bond or whatever. So I'm just putting that out there. So it would have to, it's a longer conversation and a lot deeper and stuff than what we can get into.
It just seems unfortunate that they had communicated with you yesterday and
Yeah.
that was a sign of hope, but
Well, and the thing is, all they did is they fixed some clerical errors, but they didn't remove language and stuff and that they had inserted into your form. And that was the biggest hang up.
And I, you know, I don't want to be guessing, but you know, if past is prologue, we're better off with an order saying deliver immediately, because it sure sounds like this bank hasn't exactly been performing on a turning on a dime. And so
Yes, sir.
we'll have, the order will have the language deliver immediately. And that'll be you know, that's the requirement, that's the expectation, but I would suggest that we hold our breath that it's gonna get coughed up on the 29th. We're still covered legally, which is why the notice needs to be served, but like I said, I wouldn't expect it to just happen super quick.
understood. It's hard to see a good operator be the one that really ultimately pays the price.
Yes, this all seems very unfortunate, but on the other side, clear that we need to take action as recommended. And the one thing I see that we can do is waive civil penalties. And I don't know if that's in the recommendation, that's separate.
Separate, yeah. Chris, do we know what the civil penalty was?
$3,400.
$3,400 is what we're for.
Are we looking for a recommendation, something to vote on? Is that correct?
Yes,
Okay, so I would recommend that the bond be pulled immediately. And I would assume we could, with that paperwork, we could include some kind of a cover letter to the bank that if they will comply with our, I guess our forms, if they will comply with our forms, then we would not have a need to pull the bond. But that needs to be sent out right away, and maybe that will get their attention. I don't think so, but it might. So that would be my first recommendation. Second recommendation would be to suspend all fines. And the third recommendation would be to work with this very responsible operator after the first of the year if the bond is pulled and there's no new bond put in place.
Well, I think the division is ready to work with them in the next year if we can start over again. But at this point, I think I'm ready for a motion. And so I'm going to close testimony and look for board comments or motion to move forward.
Madam Chair, I move the staff recommendation, which includes the board's confirming its decision to forfeit the financial warranty, the board issuing a finding of fact, conclusions of law and order to support its decision, and issue an order directing the affected financial warrantor to immediately deliver to the board all amount warranted by applicable financial warranties pursuant to statute, and that the board revoke number M 2013-066 pursuant to statute, and would also recommend discussion of waiving the $3,400 civil penalties, or that can be done in this motion or another one.
Yeah, you can do it in the same motion.
Okay, then I would recommend that in this motion.
I second the motion.
Okay, we have a motion and a second, and we could talk about this for hours, but I think it's pretty clear that it's complicated and we need to move forward. Do we have a motion and a second? All in favor, say aye.
Aye.
Any opposed? Okay, thank you all for all the details, and thank you. Please send our regards to the operator. We'll hope to see you next year.
We will do so, ma'am. And thank you and the entire board. And again, the staff. You've once again bent over backwards. And I know that Steve and Joyce will appreciate that very much. And I hope that this will finally get the attention of the bank. The people who can do that, not just the local bankers. Thank you.
Hey. So we'll move on to another enforcement hearing. This is file number M-2025-036, Gonzalez Hilario. And anybody who's going to speak on this needs to raise a hand and swear to tell the truth.
Yes.
Okay, thank you.
Good morning. I'm Brock Bowles. I'm representing DRMS this morning. And we are here today for an unpermitted Arapahoe Farm pit, permit number 2025036. And this is consideration of a possible violation, cease and desist order, corrective actions, and civil penalties for failure to first obtain a reclamation permit from the board. Okay, so the location of this pit is 6 miles south of Strasburg, Colorado. You can see here, this is I-70, just east of Denver. Here's the town of Strasburg, and just south of Strasburg Road. And here's the pit location. And I do want to make a point right now, is that for administrative purposes, we've assigned this permit number 2025036, but that does not imply that a permit has been issued or any permissions to mine or anything. That number's just been assigned for us record keeping here in the office, as is the Arapahoe Farm Pit. That's kind of the name we gave it for just our internal discussions. All right, so here's what the site looks like. Again, it's here's Strasburg Road. This is the Lloyd Road here. The red boundary that you can see here is the property owned by Mr. Gonzalez. And this was verified by the Arapahoe County Assessor's Office. The yellow boundary that you see here off to the western side of the property is the disturbance that we observed on our second second site inspection on October 20th. We'll get to why we got to the second site inspection in a moment, but I just wanted to give you a situation and awareness of what we're talking about here. Okay, so the chronology. Back in July 14th, 2025, the division received a phone call from an adjacent landowner regarding potential mining activities located on the land owned by Mr. Gonzalez. And on the same day, we were actually able to make contact with Mr. Rozuela, who is the landowner's nephew and a representative of Mr. Gonzalez. And during that phone call, we advised him to submit an Is It Mining questionnaire. It's kind of our process to document what is being done, what is the intention. There's a bunch of questions we ask, and then with that documentation, we can make an informed decision whether a permit is needed or not. So the very next day, Mr. Pozuela did submit the Is It Mining questionnaire. On July 21st, we actually did go out and look at the site because we did have a neighbor looking at the site and questioning it. So we thought, as part of the Is It Mining process, we did go look at the site to just document what we saw and to verify what was happening. And here's just some pictures from that inspection. And here's the front entrance gate. And one of the conclusions I made from that picture there, it didn't look like a lot of traffic was in and out of there. You can just tell by there's not a lot of tire marks and stuff like that. Doesn't mean material didn't leave the site, but it just appeared like it wasn't leaving the site. It's just an appearance. We did see a tractor on site. The site we found to be full of a lot of noxious weeds. Really wasn't like a pristine piece of land. In the northwest corner of the site, we did see the topsoil was pushed into windrows, and you can see that in the last picture there. It was piles of topsoil were just pushed up. And again, from what we could tell, all the disturbance was within the property boundary. And so part of our conclusion from this inspection was you're allowed to move soil around your property. And it did not appear that soil had left the property, and they are allowed to own large pieces of equipment. So we didn't see at this time, just from our observations, we didn't see anything that met the standard of mining. So on July 22nd, the division did issue its determination letter that no DRMS permit was required. So this was given the information provided on the Is It Mining questionnaire and what it was known to us at the time. So some of the key factors also that were included in this is that we were told that no compensation in any form will be received for moving this sand off of the site. The project did say that 69,000 cubic yards of sand was going to be removed from the site. And the purpose of that was they're wanted to bring in some topsoil substitute to enhance an agricultural project that they were going to be doing. And we were in contact at the time now with Arapahoe County Engineering Services. Please make a note of that. This is going to be a little bit of a confusing point later on. We talked to the Arapahoe County Engineering Services people. They were aware of the project. They were understood what that material needed to leave the site and for agricultural enhancement. And they've done other small projects like this before. Nothing at this scale, but they were aware of this process. And so the county, talking to them, they did believe this to be an agricultural project. So those are some of the, those are the factors that we made our determination that a mining permit was not required.
One thing to add too is that the county had issued a right-of-way permit, which would allow them to use the public roads to remove the soil. So there was engagement and permitting process in place for this project at the time.
So now fast forward a little bit, on October 15th now, Arapahoe County zoning manager, now that's a different entity within Arapahoe County. So the zoning manager contacted the division, us, and provided new information. One of the things they provided to us was that a contractual agreement between Ames Construction and Hauler LLC detailing compensation for haulage fees for the extracted material. And that contract was signed on July 18th. Now, Hauler LLC is owned by Mr. Bozella, and that is the landowner's nephew and representative and the gentleman who submitted the Is It Mining questionnaire to us. So now, again, the Arapahoe County, their zoning manager now, they no longer consider the activities as an agricultural project. And on October 15th, Arapahoe County issued its notice of zoning violation. There's the number. And they issued that to Mr. Gonzalez for earth, sand, and extracting activities. And all these documents that I've mentioned here, the notice of violation, some of the county correspondence, our inspection report, and the Is It Mining questionnaire that we referenced, it's all in the board packet there for your reference. So on October 20th, now this is the division conducted a second site inspection. Okay, things have changed. You know, we got new information. We actually did want to go to the site and see what happened, what was going on. And I got some pictures of that on the next slide, but I just want to continue the chronology here a second. So on October 30th, 2025, the division issued its reason to believe a violation exists and a notice of board hearing to Mr. Gonzalez. And all that is based on this new information that we saw. So now here's some pictures from the second site inspection. We wanted to go out and follow up and see what happened. In this picture on the left here, you can see that that is the front entry gate. Again, the gate has been removed. They put down some rock material, and you can see now a lot of truck activity has happened at that entrance gate, which really wasn't surprising to us because we did understand material is going to be leaving the site and no permit was required. That was what our determination letter said. So again, this documents that there was vehicular traffic, but it was not a surprise to us what we saw. On the right picture here, you can see they have an excavator, and you can see, it's a little hard to see in the picture. We did not enter the property this time. We did not have permission from the landowner to be there. So all our pictures are just from the road, so just trying to get an idea of what we were looking at. But we did not want to enter the property. We didn't have permission. But from this little bit of this angle, you can see that maybe about 1 foot of material has been removed. And that is what that 1 foot was documented in the Is It Mining questionnaire. Picture on the left here. This is now the west side of the property. And again, a little hard to see. It was a little hard for us to see, to judge. We can see it was a little bit deeper, maybe 4 or 5 feet deep on the western part of the property over there. The depth was not a huge concern for us. Sometime in the early stages of mining like this, They might dig a little deeper in one spot and less in another area, and then eventually it all gets evened out. You know, because they're very early on in their what they were doing in their process here. This is the 11 acres that we documented in that other map, the yellow area. So this section is just the 11 of the 40 that we knew were going to be disturbed. So in a sense, only about 25% of what we expected was disturbed here. The picture on the right here is we assumed to be property markers. We couldn't find little actual property markers, but we did see like a corner post and this white post, presumably property markers. And we just documented this point of view to show that none of the disturbance left their property. It was all contained as best we can tell on their property. So the reasons for the violations, the disturbance that we saw out there did meet the definition of affected land. And here's the definition. And it also met the definition of a mining operation. Material was leaving the site, had all the signs of a mining operation. And so here's the CRS statute, 3432.5, 109, parent 1. And this is before engaging in a new operation, a permit is required from the Mining and Reclamation Board. So we've determined that the Arapahoe Farm Pit meets the definition of a mining operation per those regulations. The Arapahoe Farm Pit does meet the definition of affected lands, and therefore we determined that a reclamation permit is required. So our staff recommendations. We recommend that we do find the operator in violation of CRS 3432.5, 109, parent 1 for failure to first obtain a reclamation permit from the Mining and Reclamation Board for engaging in a new mining operation. We also recommend a cease and desist order, and that's issued at meetings and cease order according to CRS 3432.5, 123, parent 1, prohibiting any further mining activities except those that are approved by the division. And part of our corrective actions, we suggest that the operator file a reclamation permit application as appropriate within 90 days of the effective date of the board order and obtain approval of the application within the statutory deadlines. Civil penalties. So pursuant to CRS 3432.5, 123.2, an operator who operates without a permit shall be subject to a civil penalty of not less than $1,000 per day, nor more than $5,000 per day for each day the land has been affected, and not to exceed 365 days. So in this matter, the board could find 48 days of violation from the October 30th RTB letter to the December 17th, 2025 board hearing. And that will be resulting in a range of civil penalties not less than $48,000 and not more than $240,000. In addition to the civil penalties range provided earlier, CRS 34-32.5, 123, parent 4 states the board shall also assess a civil penalty in the amount not less than the amount necessary to cover costs incurred by the division in investigating the alleged violation. In this case, the board shall assess a minimum civil penalty in the amount of $339.84 based on 6 hours of staff time at $56.64 per hour. So we would like to fine the operator in violation of 48 days and assess the civil penalty of $1,000 per day for the resulting civil penalties of $48,000. In addition to the $339.84 for the division's cost incurred investigating the violation for total civil penalty assessment of $48,339.84, with all but $339.84 suspended if the corrective actions are complied with by the deadline specified on the board's order. The payment of the unsuspended portion of the civil penalty shall be due and payable within 30 days of the effective date of the board order, unless otherwise specified in the board order. We suggest to waive all the civil penalties because we understand that we made an initial assessment and they were following that. The division changed its board, or it changed its not board order, but we changed its determination based on some new information that we got. And we do believe that there was a little bit of confusion between the of Arapahoe County, because we got one answer from engineering services, and then we started talking to the zoning manager and learned some new things. So we don't believe that the operator was really trying to be deceptive here. You know, they were not aware of the mining regulations because they approached this project as an agriculture project and was working with the county. We were brought in because of the citizens' concern. So that's why we just feel that just get a mining permit and move on and continue moving on. And that's why our recommendation is just to waive civil penalty for at this time, unless that board order is not complied with, then that all the civil penalty kicks in. Are there any questions?
So did you folks do a calculation of the 69,000 cubic yards that they thought, is that 1 foot over 11 acres?
That would have been for the entire 41 acres
1 foot for 40 acres.
or 40 acres.
And what you're talking about, the suspension within 90 days, there's 90 days to.
Yes. Yeah, 90 days to provide us a mining application. And if they do that within that time frame, all the 48,000 would be suspended or waived at that point, assuming they complied. The only thing that cannot be waived is the 339, and that's per statute, which is just to cover the costs incurred to investigate the matter.
Questions online?
Madam Chair, I have a couple questions, I guess. So it's because there was compensation to haul it, even though there wasn't really compensation to their bottom line, is what triggered it with the county, right?
Zach Joe, sorry, earlier, DRMS. Yes, that is correct. Our understanding is that was essentially a break-even cost for them. However, it is a haulage fee. So that does make it a rise to what we would consider a mining operation.
And I'm assuming that this operator has some administrative costs and hoops that they now have to jump through with the county too at this point, right?
Yeah, so they have continued, my understanding, based upon Brock's discussions, and maybe you could talk more about your personal discussions, but they are continuing to work with the county. They wish to proceed to continue their project so they can complete it. They just want to make sure that they have all proper permits in place.
Okay. Okay. Yeah, I just wanted to be sensitive to make sure that we weren't kind of doubling down on them. You know, but it sounds to me that almost issuing them the permit is the cut and dry pathway, because it also gives them an opportunity to say, okay, hey, we're done, here's the bow on top. And everyone, there's none of this kind of murkiness that we were dealing with. I just wanted to make sure that we weren't being too heavy-handed.
Yeah, and that's kind of why we recommended the suspension of the full civil penalty aspect of it as well. Just take all that into consideration.
Yeah, I mean, but you know, there's probably costs associated with their having to do some analysis and whatever just to finalize the permit. I just want to make sure that we're not going too far. But if the operator, if this is along the lines of what the operator feels like they can manage and what they want, then I can get on board with the process.
Madam Chair, Russ Means for the division, just as a point and stuff that was brought up. When it comes to compensation, and that the board has always had a kind of a very broad definition of what that means, because, well, in this case and stuff, and that there, there's certainly not that issue, but in the past and stuff, we have had operators who have tried to say, we're just doing it for, for haulage fees or whatever, or in that, and of course, the haulage fees and stuff are, $100 a ton or something like that. So, that's not that's not for us to determine and stuff what that is, but any kind of compensation whatsoever is always that line and stuff that crosses over into a mining operation. Is they're getting some kind of compensation, whether it's for fuel costs, haulage fees, whatever and stuff, and that it's a pretty broad category that the board has historically and stuff held to. So just wanted to make that distinction and stuff for the board. And thank you for that question and stuff now.
Madam Chair, I have a question. What's the length, the duration of this project? How long is it? I mean, are we looking at 6 months or a year? What are we looking at?
The operator and landowner or representatives of the landowner are here. They could have a better idea of the time frame and the scale of what they're wanting to move forward with. So we don't have that information on the duration of it necessarily.
Okay, so it's open-ended then, correct?
Could you repeat the question?
At this point, it is an open-ended project.
Open-ended.
Yes, the county has already issued their own personal cease and desist, so they're kind of in a holding pattern at the moment.
And they would permit the 40 acre.
That would be up to them. They have options based upon, the permitting that's available to them. The initial project as presented to us was about that 40 acres. If they choose to, they could limit it to just the 11 acres that they've currently disturbed.
And because if they do the 11 acres, they can go to any depth or a different depth.
Yeah, with a mining permit, they can then go to any depth or that they wish to choose, and they can also, set a compensation aspect, assuming they have all mining permits and county permits in place.
Any more questions for staff? Thinking we might want to have operator representative. Come on up and tell us your name. Yeah. They raised their hands to swear in earlier.
And then Chivalio Gonzalez.
I'm Jose Gonzalez, his son.
You want to give us your plans or experience?
Well, I don't know much about this, but I try to explain the most I can, but I don't understand when I got the permit and all that. And then I have to come here. I don't know. Maybe my son can explain more about this because he's around. Okay.
Yeah, so I guess I've been a little bit more involved in the project. Our main objective with the project is trying to get the land to be able to use so that we can grow vegetables on that property. Because with that land that we have, it's there's sand under, so it just kind of goes through the dirt and it gets, we need something that's more the water can hold in the dirt. So that's the main reason we're doing the project. Getting the permits, we thought we were doing the correct thing, because obviously we can't just do something without the county and I guess now the state being involved. So we understand that, we understand now what we need to do. We understand that we can't just, if we decide to expand the project, we understand that whatever we put back into the land cannot just be any type of dirt, which we kind of understood that from before. We can't contaminate the grounds. As far as what he said, as far as like how long the project would be, we've been through a lot of hurdles with the county. They tell us to do this, we do it. Then they tell us to do this, we do it. Then they stop us, and then we pay the fine, and then they let us work for a little bit more. So there's been some miscommunication, as Brock said. We hope that all that miscommunication is gone. And we want things to be very clear with the county, especially the county, to proceed. It hasn't been the easiest to work with them. Just to give you guys a little insight, we've gotten CDOT called on us. Well, the operator has been called, by CDOT's been called on them, checking every diver. Unfortunately, that neighbor that called on us, the concerned neighbor, which is fine. She's there every day that we worked. She was on her property, which is fine, taking pictures, video. So she's been she's even called the sheriff on us. She's called the state, obviously, you guys. So yeah, that's kind of discouraging for us because we're like, well, we're not trying to do anything to provoke anybody, any harm to anybody or, you know, any unpleasant activities or whatever for her. You know, she lives on just south of the property. Her house is a little bit of a distance away, but it seems like there's been a lot of obstacles, I'll say. And we've tried to go through those obstacles and hopefully we can keep going. If we're allowed to, obviously. I don't know if you have any questions for us.
Are you okay with the 90 days to get a permit and?
Yes, yeah, I've already spoken to Brock. He kind of outlined what I need to do with the state as far as the permit that I need, which is, I believe, a 112 permit. What it allows us to do, what it doesn't. The operator's been talking to the county also to see what permit we need, the correct permit. Because like I said before, we thought we had the correct permit, but then we didn't. But they allowed us to work that time. So we were kind of confused, yeah.
Madam Chair, I have a question while the operator's available. It also, I guess it relates to what this would look like. I mean, again, state of Colorado does a great job on making sure that an operator has a reclamation permit before they start doing something. But how do we remedy this? And does this family then need to have this permit, for lack of a better term, open the entire time they're trying to have an agricultural operation on this land, which is the reason that they were augmenting the soil? I'm not sure that, you know, again, I understand that receiving compensation for haulage of some soil equals, is it mining? However, the times that we've seen this previously, it's to dig out a pond or it's to dig out a culvert or something like that. These guys are actively farming on this land. So are they then going to be at the mercy of keeping this open for as long as they're successfully able to farm it and have to file all the permitting fees and the annual filings and all of that? It just feels unduly burdensome.
Madam Chair, Russ Means and stuff and that I can respond to that and stuff. But for this, it's always tricky and stuff when we're talking agricultural projects and stuff and no, the answer is no, they would not have to have this permit and stuff once, and that the activity and stuff that's proposed is the removal of this material and stuff and that so that they could reestablish a better agricultural field. Once that material is removed and they're back into just strictly agricultural projects and stuff and that, then we don't want any oversight over that. That's certainly the landowners and stuff, activities and stuff, and purely agricultural. So it's just the activity of removing the material for compensation and stuff and that prior to, and that crosses that line, if you will. So we're not looking to watch the corn grow. That's not our purview and stuff there. We just want to make sure and stuff that it does get back to that point as part of the permitting process. They will let us know and stuff and that, you know, that they that what their post-mine land use is, and once they've achieved that, then yeah, we're out of the way. So if they're going to go back into agriculture, then there's certain standards and stuff there. We could talk about that and stuff. And when they're there, we'll release that permit.
But that being said, let's say they say it's agricultural, they remove this soil, that part's done, they start farming. In other instances, when we've had a post-mine land use, there's something in the permit that says, you know, when something is satisfactory for 2 years, when it's 5 years, when it's whatever. Are these guys going to have our department coming in and checking on their farming operation because they're now tied to a 112C permit? Or truly, like, next, say, whatever, May, the soil has been augmented and the planting starts, and you go in there and you say, this is a done deal, everything that was related to this 112C permit is released?
Within the Russ Means again, within the act and the rules, there's actually they provide us with stuff of what their normal yield and stuff is, and I don't have, I can pull it up here and stuff, hadn't had to dig for it, 'cause it's been a while, but there's a standard there. But yeah, if we were to go out and see that you know, that crops are planted and it's doing its thing and stuff, and that, then we would not have any issues stuff releasing the permit, so.
Okay, but these guys are going to have to bond for a 112C permit.
That's correct. Or, you know, if they keep it under 30 acres, they could do this as a 111B. That would qualify and stuff there. But the kicker there is that 30 acres or less. So it depends on what they want to do. And that's why we didn't prescribe a certain type of permit. We're leaving that option and stuff open to the operator to decide and stuff what their business model is and decide what they want to do. You know, do they want to just reclaim what they've got and step away? Do they want to expand that and stuff to the to 30 acres and keep it as a 111B, or do they want to go ahead and do a full 112C? So, but that's their and stuff in that we're not trying to prescribe that.
I have a question of the operator. So the material that's being removed, Ames is using it for road construction or some
The
other?
operator is not here, but he had to leave in an emergency. But as far as I know, yes, they're using it to build a highway, I believe, or something like that.
So it's meeting the specifications.
Yes.
Ames has made sure
Yes.
your stuff is good enough to do
And
that.
he's also, just not to cut you off, but he's also already looked into the topsoil that needs to come back in to the ground that we're needing, that we need to fill back in. Also, that meets the specification for the state also,
Okay.
which is non-contaminated, right?
And so if you get a permit, a 112 or whatever it is, if that material is being spec for a highway, is there maybe a greater good of that property, at least temporarily, for as a quarry versus agricultural property? Have you guys thought about that? Taking more than a foot, going down 5 or 6 or 10 feet?
We haven't really thought about it. I mean, we know there's.
They don't have an idea about it.
Yeah, I don't know. Not yet, no.
Yeah.
We're kind of just
curious.
jumping into it.
Right.
He's owned the land
Right.
he's owned the land for
years.
5 years.
Okay.
We've never had to do a survey, like, the surveyor called me one day, hey, what are you using the land for? Now they need a lease with somebody that's gonna farm it to keep it as agricultural. Like, there's a lot of obstacles that, you know,
On the
like
other
I've
side
told
of
you
the
before. I don't know who called. I mean, I have an idea, but I can't confirm. So, and like I told him, I said, he's never had to tell you what he's using this land for. It's been just like a vacant agricultural lot.
You
Because
haven't farmed it today.
we don't know what we want to do. Yeah.
Yeah.
So now he wants to do something, and now there's some sort of movement. Now there's an issue,
Yeah.
which is, I mean, I guess it comes with the territory. So.
And so the Arapahoe County zoning,
Mhm.
that zoning violation is just for the access?
I'm not sure.
Rezoning? Does that make sense?
From my understanding, the permit was pulled because we didn't have the proper permit. That was my understanding.
To access the property
No.
or extract? To
Ju-
extract.
We didn't have the proper permit, I guess, to extract. Yes, that's correct. To extract, I guess.
So they would rezone it from agricultural to something else? local
If we,
property,
if we
or-
don't, have a lease by the end of the year with somebody that's gonna farm it, they will rezone it to vacant land instead of
Oh.
agricultural land.
So, Mr. Baker here, I have a question. The material that you're taking out of the property is being used as road base for a highway project. Are you being compensated for that?
Who was he asking that to? The operator or
Are
us?
you being compensated?
So you're giving it to them for free?
No, we're trading. They're not charging us for hauling the stuff. So they're taking the material because everything costs, right?
Yeah.
So instead of them charging us, they're selling it to them.
I see. So you're trading
Yes.
the sand for
No.
a better earth, a better.
No, it's just topsoil.
Yeah, for a better soil.
Yes.
Okay.
When they bring the dirt that needs to be filled back in, yes, it has not been filled back in yet.
Okay. All right. Thank you.
Well, it sounds like if you get the permit, then you'd have options to do what works for you. You might decide you want to do more mining and
More money.
some ag
Well,
or whatever works for you.
it's interesting you say that. We know somebody that owns a sand and gravel company. So it could be an option, but I want to get his guidance also or from you guys. I don't know. I mean, I'm free to listen to your guys' recommendation. This is the first time I've ever had to be here, so especially and him too. So I mean,
Gravel's in demand as well as vegetables.
exactly. See?
But it does give you some flexibility to
Yes.
figure out what you want to
Yeah.
do moving
Yeah,
forward.
and that's like I asked Brock, I said, what does this permit allow me to do? What doesn't it? Obviously, that's just with the state. The county also needs to okay it also. So. Yeah.
I mean, I'll just make a comment for the operator. I think you guys are doing a great job understanding, drinking from the fire hose, I'm sure, but I've been on this board quite a while, and I can assure you that the staff and the division and the resources that you have are really wonderful. And, everything that comes across this table, we typically hear from the operators that, they've really been able to ask good questions and get really great support from the staff. So I know that this has probably been a little bit of a surprising, frustrating experience for you, but maybe it is, an unintended pathway that you could have an interesting viable use for some land that you hadn't anticipated. So I think that Ms. Nelson brings up an interesting point. And of course, it's not for us to sway you in one direction or the other, but I just want to give you some assurance that even though this isn't probably how you're wanting to spend your time right now, it might be you're in a good spot in terms of resources and being able to ask questions of folks once we get some of this squared away.
Hey, any more questions, comments? Maybe I'll close testimony and go to board comments, motions, suggestions. Wendy.
That's a great.
I move that we adopt the staff recommendations for both violation, cease and desist, corrective actions, and the civil penalties, with the caveat around the compliance within 90 days to get that permit in. And then all that will be waived, and if not, there's, a bigger consequence there.
Yeah.
Second.
Okay, we have a motion and a second. to approve the staff's recommendation, including the suspension of civil penalties, except for the 339. And within 90 days, we'll hope a lot of good happens. All in favor, say aye.
Aye.
Any opposed?
Aye.
Oh. Baker is opposed, or your aye in favor?
Opposed.
Opposed. Okay. Motion carries. So we'll move forward. Thank you all for being here. Good luck.
Thank you. Have a good rest of your day.
You too. And our next enforcement hearing was continued. So we are moving on. Oh, we have another enforcement hearing. And this is file number M 2002-118. Old Castle Southwest Group.
Last one of the morning.
Yeah. Yes. I think your 10 minutes could get it. No, that's right. But. Might be better. I think it's. Okay, I'm sorry, we're gonna take a break for, should we say 20 minutes, 15 or 20, because we have a car movement emergency. So
Get set up.
we'll come back in 15 to 20 minutes and start over.
Sounds good. Thanks.
She can run. I think we're about ready to get back to order here, except our presenters disappeared.
Texted Amber, she should be here.
We lost our special.
Okay, we're about to get started, but we're waiting for our presenters to be front and center. This is going to be enforcement hearing file number M-2002-118. And it's Old Castle Southwest Group.
Sent someone down to look for her. I apologize.
There he is. Sorry. Hey, I guess, oh, I do need to have anyone speaking on this, raise hands, swear to tell the truth.
And then we have one online as well.
Okay. See that hand up? Think we're ready to go.
All right. Well, good morning. My name is Amber Gibson, and I'll be representing the division in this enforcement action. This hearing is for the Velarde Pit, permit number 2002-118. And it's permitted to and operated by Old Castle Southwest Group Incorporated. This hearing, oh, sorry, I gotta fix something on here real fast. Oop. Oh no, I messed it up. Help. That's what I meant to do, but I meant to move this. There we go. Okay. Sorry. This hearing is for the consideration of a possible violation, cease and desist order, corrective actions, and civil penalties, and for failure to protect areas outside of the affected land from sites or damages occurring during the mining operation, and or for failure to first obtain from the board or office a reclamation permit prior to engaging in a new operation. So the Velarde Pit is located approximately 13 miles northwest of Wilsonburg, and it's on the south side of County Road 613. This site is permitted as a 112C regular construction operation, and it encompasses 300 acres. The commodity mined at this site is sand and gravel, and the post-mining land use is rangeland. The division currently holds a bond in the amount of $201,517, and that is adequate at this time. So I'll just briefly go through the chronology that brought us here today. Beginning on September 10th, 2025, the division conducted a routine monitoring inspection and found that the operator had affected 12 to 14.7 acres outside of the permit area. Then on October 21st, the division issued a surety increase following the inspection regarding the on-site disturbance and the observations made during the inspection. On November 13th, the division sent the permittee a reason to believe a violation exists and notice of board hearing. Then on November 17th, the division sent the permittee a notice of acceptance of those financial warranties for their response to that surety increase. Which brings us to today, December 17th, 2025, for this Mineland Reclamation Board hearing. So in the next portion of the presentation, I'll be addressing the areas where the division believes that land has been affected outside of the permitted boundary. But there's two focal points that I want to draw your attention to as we move through the slides. First is that the approved haul road is located on the west side of the permitted area. And the second is that the approved maps state and that they show that there's a 200-foot offset between the property boundary and the permit boundary. So this is that approved mining plan map for the Velarde pit. This is operated as a phased operation, and that includes 3 phases. But since mining began at the site, the only area that has been mined is this phase 1 area up here. So we'll just zoom in and look at the features in the northern portion of the site because that's where all the activity has been concentrated. So again, I just want to direct your attention to a few features while we're looking at this. First, that the approved haul road is located on that west side of the permit, branching off of County Road 613, which is this black one here. And then it follows an existing ranch road through the property. The haul road that's approved is supposed to enter phase 1 on the southwest side. Next, I just wanted to highlight that offset between the property boundary represented on the map, which is that purple dashed line, and then the permit boundary, which is the green dashed line, and then the affected land boundaries, which are those orangish, reddish dashed lines. And then also, if you notice on the north side and the east side of that phase 1, it aligns with the permit boundary. The affected land and permit boundary are the same. And then last, I just wanted to highlight that 200-foot buffer is not only like shown on the map, but it's also explicitly stated that there will be an offset. During the site's original permitting process, the division conducted a pre-operation inspection and sent that inspection report to the operator on February 4th, 2003. The inspector stated in that inspection that the arroyo would not easily be crossed by haul trucks without significant upgrades or alterations. And then in response to that, the operator stated that they would supply arroyo crossing details and plans, which they did in the adequacy response. The inspector also noted that even though they plan on using pre-existing ranch roads for the operation, they would need to be substantially upgraded and they would need to be included in the affected land. And they were included on the maps through adequacy responses during that initial permitting process. And then last, the inspector also noted that during the pre-op inspection, there were property boundaries or affected land boundaries marked, but he noticed that they were within 50 to 75 feet of that property boundary, whereas like it had explicitly said it'd be that 200-foot offset. And then at that time during the inspection, the operator representative stated that they will remark the boundaries to match what they had said. I just wanted to highlight the pre-mining map also shows that 200-foot offset. It's stated, and then it's also shown explicitly in that northeast corner. All these say 200 feet offset. But as a disclaimer, there are discrepancies regarding the property boundaries. So I highlighted the property boundary on the approved mining plan map screenshot right here in yellow. And then this image on the right is a Google Earth aerial image with data from the Huerfano County Assessor site pulled in. So that is the parcel configuration that matches this map. And you can see it doesn't quite match it exactly. But in addition to that, there's also a fence line that's in the north and east sides of that phase 1 area that doesn't exactly match the parcel boundary either. So we'll zoom in on those areas in the next few slides, just so you can kind of see that a little bit better. So we'll just go through a time lapse for the next few slides. This image was dated September 24th of 1999, and the original permit application was received 3 years later in 2002. So this is what it looked like before any mining had occurred. This white outlined, or the white outlined parcel again is that parcel from the assessor site. And then this dashed line is the fence that exists in the field. So you can see the parcel boundary is a little bit further south than what is depicted in the field. But by June 16th, 2005, the site was permitted and operations still haven't begun. But by June 18th of 2006, operations and excavation had begun at the site. So again, that white dashed line highlights the fence in the field. And even if the operator had assumed that the fence line was the property boundary, we can see areas within 200 feet on the north side and east side of that fence have been affected by mining. These arrows highlight the location of the approved haul road. And the haul road was again to be substantially upgraded, and the Arroyo crossing was supposed to be upgraded as well, but it doesn't look like that had been done. But also at this point, there's a new haul road coming in from the northeast side, entering the phase 1 on the north side. And then I just pulled up this as a visual again to show that offset that's supposed to be there between the property boundary and the permit boundary, and to highlight that there's no road that exists up here on the map. By April 4th, 2006, it appears that that northern road is used as the primary entrance and that the disturbance on the east side meets with that fence line. I do also want to note that this disturbance beyond the fence line is because there's another permitted operation on the other side. So that wasn't them, that's another permit, but everything up to the fence line is included in this operation. Then as of September 24th, 2013, we can see that there's some berms up along that northern fence line. So it's all right up against that fence on the north side as well. And then the division's 2019 inspection report mentioned the addition of a scale house along the eastern portion of the site. And then as of this September 13th, 2019 aerial image, it appears that scale house was still in place. But we can also see that some reclamation had been done at this point. All of those pit slopes have been backfilled and graded, but no topsoiling or revegetation had yet occurred. And then this is the most recently available aerial imagery, and this one's dated March 15th of 2025. And this appears to reflect the same conditions I saw during the September 2025 inspection. As mentioned in the slide before, the pit slopes have been backfilled and graded, but as of this inspection, still no topsoiling or seeding had occurred. And there were some small erosion rills starting to form on those regraded slopes. I just want to also note that what I saw in the field included disturbance going up to that fence line. Some product stockpiles were still on site too, just for what the site looks like right now, and that there's a topsoil pile. But also I saw remnants of that scale house. So the scale was no longer there as of the 2025 inspection, but you could still see where it had sat. So at the September inspection, the operator led the inspector to the access road highlighted in those previous slides, located on the northeast side of the permit boundary. So that's that phase 1 area. And if we zoom in, that's that northeast new road. And in this image, we're looking from that county road right here. So we're looking this direction along the road. And then again, just to highlight, the approved haul road is on the west side of the permit boundary, entering on the south side. There's no road represented in any of the approved maps on that northeast side. The road was inaccessible at the time by vehicle because of that temporary impassable berm that was in place. So we just walked along that road to get in. And at the time of the inspection, the division informed the inspector or the operator that this haul road was not approved and that it would be cited as a possible violation. During the inspection, a couple markers were located around the perimeter of the phase 1 boundary, but were quickly identified as being incorrectly placed as they were both posted right next to the fence line. So this marker was located on the north side along the northern fence. And this is looking from location 4 on the inspection map, looking east. And you can see that there had been like a graded berm here, and from the absence of the yucca plants on this side, that all of this likely had been disturbed at some point. And then this one was along that eastern fence from location 13 on the inspection plan map, or the inspection map. And looking north, you can see that disturbance meets the fence line as well on the east side. By the time of that 2025 inspection, again, the scale was no longer on site, but the remnants of the equipment or where the equipment had sat were observed, and that's just a picture of that. And then in addition to the new haul road on the north side of the permit boundary, temporary internal roads were also noted along the north side or the north fence within that 200-foot buffer. So in summary, in the 2025 inspection report findings, the field observations found that disturbance within the affected areas off-site included the construction of that new haul road and that internal road. Berms that were located outside of the permit boundary and the remnants of a truck scale that had sat outside of that permit boundary as well. And then review of available Google Earth aerial imagery post and pre-inspection noted that there were also equipment parking areas within that off-site area and some stockpiles too. But I do want to note that there is no evidence that those off-site areas had been excavated, but they have been affected by mining. So combining all these observations, the division estimates that approximately 12 to 14.7 acres have been affected off-site or outside of the permit boundary. And then I mentioned earlier that the parcel boundary and the fence lines in the fields don't match. So when looking closer at that parcel boundary, which is that white solid line, and the fence line, which is this dashed line, you can really see that offset when we're zoomed in between the fence line and the field. So the discrepancy between the estimated acreages are because on this left image, that yellow polygon is where we're getting that 12 acres, and that's from measuring from the fence line as the property boundary, moving in 200 feet, and everything within that 200-foot diameter is considered off-site, plus the road. That's where that 12 acres estimate is coming from. Then on the right side is looking at that green polygon, and we're measuring that 200-foot offset from the parcel boundary moving in. And then in this case, everything within that parcel boundary, 200 foot in and beyond, is offsite. So that's where that 14.7 is coming from. So the division believes the reason for a violation is that 12 to 14.7 acres have been affected outside of the permit boundary, and that the affected acres meet the definition of affected land pursuant to the statute and the rules, and the definition of being part of a mining operation pursuant to the statute and the rules. In accordance with CRS 34-32.5-116, parent 4, parent I, areas outside of the affected land shall be protected from slides or damage occurring during the mining operation and reclamation. Also pursuant to CRS 34-32.5-109, parent 1, before engaging in a new operation, an operator shall first obtain from the board or office a reclamation permit, where in accordance with CRS 34-32.5-123, parent 2, an operator who mines substantial acreage beyond the approved permit boundary may be found to be operating without a permit. Additionally, the grants, condition, and agreement parent 1 section of permit number M-2002-118 indicates that the permittee is bound by all applicable requirements of the Act and all applicable rules and regulations of the board. The permittee has violated this provision of the permit by failing to comply with CRS 34-32.5-116, parent 4, parent I, and CRS 34-32.5-109, parent 1, and can be found in default of their performance warranty. The division, though, would like to highlight that in considering this possible violation, there are a few pertinent extenuating circumstances. First is that the current permittee acquired this site in 2021, and they have not operated out of this location yet. And the original permittee also never began activity at this site. A successor of operator's revision was issued in August of 2005 to APC Southern Construction Company, LLC. And that permittee is actually who conducted all the mining and the reclamation activities at this site to date. Also, for full disclosure, upon doing a thorough file review before and after the inspection, there are some discrepancies pertaining to the approved map shape and the reported acreages. These discrepancies include inconsistencies in shape in the lower portion of the permit area, incorrectly reported acreages, and unapproved maps that were used to demonstrate an idea, but they might have ended up causing some confusion as to what was actually approved in those areas. But regardless, we don't believe that those discrepancies pertain to the areas that were highlighted today, as the Hall Road was consistently reported as being on the west side of the permit boundary, and that all of the approved maps have that 200-foot offset between the permit boundary and the property boundary. But because the current permittee inherited these issues and because they had not been observed by the division prior to their acquisition, we're recommending leniency in our following corrective actions and penalties. The division recommends that the board finds the operator in violation for failure to protect areas outside of the affected land from slides or damages occurring during the mining operation pursuant to CRS 34-32.5-116, parent 4, parent I, and for failure to first obtain from the board or office a reclamation permit prior to engaging in a new operation pursuant to CRS 34-32.5-109, parent 1. The division recommends that within 90 days of today's Mine Land Reclamation Board hearing, that the permittee submit an amendment application to encompass all the affected land at the site and obtain approval of the required revision within those statutory deadlines. Pursuant to CRS 34-32.5-123, parent 1, the division recommends that the board issues a cease and desist order prohibiting any further mining activities located on land outside of the approved permit boundary, except those activities approved by the division in writing as necessary to comply with the conditions of the order, prevent damage to offsite areas, or to protect public health and safety until corrective actions have been resolved to the satisfaction of the division. The staff recommends that the board assess the civil penalties pursuant to the following statute, which states that an operator who operates without a permit shall be subject to a civil penalty of not less than $1,000 per day, nor more than $5,000 per day for each day that the land has been affected. So the division believes that this site has been in violation for 34 days, beginning on November 13th, 2025, when that RTB was issued, to today, December 17th, 2025, at the board hearing. The staff recommends that the board also assess the civil penalties pursuant to the following statute, which states that in addition to the civil penalties imposed in subsection 2, which was the previous slide of this section, the board shall also assess a civil penalty in the amount not less than the amount necessary to cover costs incurred by the division in investigating the alleged violation. The investigation cost is currently set for $56.64 per hour of division time, where the division believes that approximately 8 hours of division staff time have been spent investigating the violation. Therefore, the division recommends that the board assess a civil penalty of $34,000 for operating without a permit and $453.12 for investigation costs incurred by the division. The division recommends that all but the investigation costs of $453.12 is suspended if the operator complies with the corrective action. So this brings the total civil penalty to $34,453.12, the total suspended penalty to $34,000, and then that sets the total minimum required penalty to be paid by the permittee within 30 days of the effective date of the board's order at $453.12. Questions?
I have a question. Sorry, this is Allison Tarrant online. Has the operator been required, or would it be possible to have them do a professional land survey based off of section corners? Sometimes the assessor's shape files don't always match the section corners because of updates in GIS or potentially using NAD 83 versus WGS. So I would recommend that as a potential requirement as well to rectify the offset between the fence line and what the assessor's office has.
Definitely. And when I spoke to the operator, I believe that they were already planning on doing a survey, regardless of what happens today.
Great.
I have questions about the road in the north.
Mhm.
It seems like that's a more efficient way to get in and not going through the arroyo. And is there, I didn't see anything dealing with that, but would that be okay to use that road?
As long as it
Forward.
gets permitted and, they get all of the required notices out, right of entry, everything like that. That goes along with that road that's not currently approved. Because it's not within the affected area. And that was kind of highlighted during that initial pre-operation inspection, like, are you sure going over the arroyo is gonna make the most sense? And at the time, that was kind of what was agreed upon, but yeah. Subsequently, they decided also that northeast made a little more sense to them. And there also seemed to have been like a landowner agreement and all this stuff, but nothing like official in our records of that road ever being there.
Yeah, through the corrective action process, they can include that area as affected land within their permit boundary. We can have a reclamation plan for it. We can hold a bond for it if necessary, and
County will be noticed.
county will be noticed, and we'll have to provide documentation. They have legal right of entry to use that, because we currently don't have that either.
Any other questions?
We also have the operator here too, if you'd like to speak.
Okay, maybe we can move on to operator speaking.
Yes, a lot of this stuff was documented, limited documentation by, the previous operators and landowners, and there were easements and agreements for that road, but we acknowledged that that was not permitted, as Amber has discussed, and
Ma'am,
we.
could you please identify yourself for the record?
I'm Sarah Weimer. Sorry, I'm representing Old Castle Southwest Group. My apologies. But yes, so we did, a thorough investigation, but because those who had permitted it in the past had limited information, some of their attempts at getting these lands and stuff weren't approved. So I think that's where that confusion came in of what they could do with their old things. So after, doing the site walkthrough with Amber, we agreed, like, yeah, we really want to survey this and get a better idea of what's going on. We were able to find other previous easements with the landowners, but unfortunately all are not available anywhere, and original engineers on this. So we're, as a current operator, going to take this on and make sure we have waited to do any changes until we got in front of you guys and this was addressed, that we could, act accordingly and do what we need to do with you guys.
So as far as you know, you'd like to have that enlargement
Yeah.
in the permit.
Yeah, just because it, like she said, it does look like it was affected, so I'd like to make sure that it's accounted for accurately. And do note, as the operator on the other side of the fence that she had mentioned, our company also owns that side of or operates the other side of the fence as well. So, I mean, kind of worked out in that way for us. But yeah, we just want to make sure that it's, up to par for the state and make sure that we're doing what we need to do. So we have already reached out to other folks and the surveyors, and Amber had given the 90 days, but to get the survey and make sure that we have people. We also do kind of a seasonal thing in operation based on winter, but having enough time to make sure that we can get the surveyor markers identified, things moved out there. If we could request a longer extension, if at least maximum of 6 months, if that was possible for this amendment, to make sure that we can survey the land, clearly identify the boundaries and mark them, and then make sure that we get that amendment in as well.
So you're asking for it to be 6 months?
If possible, but we'll.
And in that period of time, you're not able to do any mining?
Yes. And we acknowledge that as well. And we've talked to many of our company's owners, and they're aware of that. There will be no activities in that time as well.
And the surety bond has already been increased for that acreage.
Correct. Yep. And provided yet to Sarah and everybody, the division already. So.
Questions, comments from anyone?
This is Allison Tarrant online again. The only question I had is, since the access road is not permitted, waiting 6 months means that, I guess no access at all would be allowed, not even just to go in and see it. Is that correct?
You can walk up there if Amber had the picture and it sent that they had burned it off. The landowner who owns that part of the property had pushed up some dirt on his own. So he is almost even blocked the access anyway. So we would have to work with his now son, who's the executor of the estate on that berm and access. So right now you can only walk up to it in the meantime anyways.
So that would be yet to be determined.
Yeah, yet to be determined. And again, the landowner to the east is the executor of that estate of that property. So we can work with them as needed.
And Amber, I think, was kind of nodding when we talked about 6 months.
If I could.
Okay,
Excuse me.
go ahead,
Coming.
Benjamin.
Oh, this is Ben Langenfeld. I'm with Lewicki and Associates. We work for Old Castle on their permitting items. The desire for the 6 months is entirely down to how hard it can be to get surveyors, particularly in rural Colorado, scheduled. Obviously, if we get this surveyed and put together fast, we can get the amendment in. It's a straightforward sort of amendment. We just don't want to create a administrative bind if getting a survey all in place and dusted takes a while.
Or you hear that? Any other questions, comments? Oh, yeah, what's on it?
Yeah.
That 180 days.
Yeah, this is Jerry with the division. Typically we definitely wouldn't, have any concerns about that addition of time. We definitely recognize the challenges in permitting. Sorry.
You're fine.
One of the reasons we put kind of a tighter deadline on that is the last time the site was in operation that we have on record was in May of 2017. So we're kind of bumping up against that 10-year limit of temporary cessation. So that isn't before the board, so we didn't bring that up. If in the future that may be a consideration for the board. But they do have a limited amount of time in order to either start operating again or complete reclamation before that 10-year mark comes to us. So we've wanted a little bit tighter of a deadline. So yeah, 6 months, that puts us in June of 2026. By the end of that review period, we're going to be getting close to 2027. And in which case, by I think May, correct, is the last date of inspection or last date of operation. That 10-year period will kick in.
May of 27.
2027.
I'm guessing if New Castle wants to operate, they will operate.
Yeah. So just
Yes, and I have identified with some of our operators down there in regards to the stockpiles. If we've got stuff to be moving or doing with our reclamation, if they need to use that kind of these stockpiles as an opportunity to kind of get in there and utilize that, that is available. But I said, again, we were going to wait for your all decision on, our actions and moving forward and the best thing for us to do.
And there is already, like she said, plenty of product stockpiles available on site. So it wouldn't be like a novel amount being moved if they do begin operations again.
We don't have any minimum operation is 1 or 2 loads of, or is there
More than token amount.
more than token?
Yes.
the way the rule reads is token, not ever mysterious word.
I like that.
And Russ made for the division, and just that's where the language and stuff comes in and stuff for activities and stuff approved by the division in writing. So the operator and stuff, we get things rolling and that we can review what they want to do with removal of stockpiles and other things, which are part of the mining activity, would kick that temporary cessation 10-year out. So we have that ability and stuff and that to work with the operator. So
as long as the operator's planning to get started after
Yeah.
that period of time, it shouldn't be a problem.
Yes. Yep. Yeah, just wanted to wait for your approval and see where to go.
And then in the event that mining doesn't continue or they don't want to quite stop yet within or before that 6 months is up, they can apply for TC, but we need to have this application approved before that, because part of the prerequisites for approving a TC is that there's no outstanding issues at the site. So that's why we didn't do that at the same time or first. Like, this needed to be addressed first.
Okay, well, I'm feeling comfortable moving forward. There are no other comments. I will end testimony and go to board comments or motions.
Madam Chair, I move to accept the staff recommendation, which includes assessing the civil penalty, but waiving all but the minimum penalty. That's sufficient.
Extending from 90.
And extending from 90 days to 6 months.
A second. Okay, we have a motion and a second. All in favor say aye.
Aye.
Any opposed, same sign? Okay, unanimous. Thank you all.
Thank you.
Thank you.
Good luck in the next 6 months. Okay, we're gonna move on to a discussion item, which is our mine subsistence protection program, which there's always a lot to talk about.
I shouldn't be
Ready?
prattling on nearly as long as I have been this time, with any luck.
You're getting ready. Yeah, is it more common in the winter or the summer to have actual subsidence?
I think it mainly depends on in
Water.
my opinion, kind of the water flow, like drainage, tends to make things a little more, I hesitate to use the word catastrophic, but more obvious.
Yeah.
So, we tend to have more subsidence emergencies that IMRP handles, typically in the spring. So, unless we get a crazy amount of snowfall that melts really quickly, but it's usually springtime. Hey, good morning, afternoon. I'm Deb Zach with the Division Mine Subsidence Protection Program through the Inactive Mine Reclamation Program. Madam Chair, members of the board, gonna go through this today. Today, we're going to talk to you about the Office of the State Auditor's recommendations. I believe I've provided in the board packet the final report that was done or finalized back in June of this year
in the board packet. So kind of be following along some of the recommendations today. And then there are others that I'll kind of get into in a table later on that are due in June, and then others that are due in December of 2026. So we'll be going through their recommendations 1A and 2B, and then what we have done to meet those recommended requirements from the state auditor. Recommendation 1A is that the Department of Natural Resources should ensure that the Mine Subsidence Protection Program's federal grant agreement and program rules are up to date and reflect the controls it intends to use for the program, and that it complies with the program requirements. This is basically stating that we need to work with the Office of Surface Mining Reclamation Enforcement, or OSMRE, to renew the program's grant and memorandum of understanding. And this will include updating the MOU's plan of operations to ensure that it aligns with the program rules and practices. The next slide, basically, I'm going to kind of do this. Here's the recommendation, here's how we're meeting it. So these are the actions that we've taken. Thus far, we've engaged in discussions with the OSMRE on how to best update and modify the existing MOU's plan of operations. Although due to significant turnover at OSM following the administration transition and the subsequent federal shutdown, any implementation date is kind of subject to that federal agency, their internal processes, and they're currently undefined. But OSM did concur with the implementation date for recommendation 1A. So we've got that in the works with them, and we're just waiting to hear back from them. Recommendation 2B from the state auditors was that the Department of Natural Resources should ensure that the MSPP within the DRMS is providing protection against the risk of mine subsidence, and that we're able to increase participation, ensure the sustainability of the Colorado Coal Mine Subsidence Trust Fund by reviewing the program's use of contractors to conduct home inspections. And this includes evaluating the potential to reduce costs by using contractors with less technical experience to perform enrollment inspections, as well as establishing guidance regarding the maximum amount that should be spent on inspections, considering the type of inspection and its purposes. And the implemented inspection cost savings to meet that required recommendation. The current program administrator's evaluation of the range of inspection costs under the current contractor, who's Tetra Tech, has resulted in the following actions so far already. We have implemented a tiered approach to inspections by completing more highly detailed floor level survey inspections only at homes that lie within the known high and severe subsidence risk areas. And this has already, I implemented this, I want to say 2 or 3 months ago. And this has already saved approximately $600 per inspection for those home enrollment inspections with Tetra Tech. Additionally, we're looking at increasing the program administrator's contributions on various components of the inspection reports. So basically at the time right now, we're having Tetra Tech provide this tome of an inspection report, but there are sections within there that I'm capable of providing, and that'll cut down on their required costs to do parts of this report, such as creating all of the maps and figures for the report, compiling the historical and background in mining information, and then writing this fairly lengthy cover letter. As well as currently we have a professional engineer at Tetra Tech review the entire report, which takes a bit of time, and then stamp the report with their PE stamp. It's not in the rules, it's not really necessary, especially for these initial home inspections. So we're looking at any potential implications of cutting that particular review out and that stamp of approval. And it's been estimated, I worked with Tetra Tech to kind of get an estimate of what those hour reductions in terms of the report writing that I would end up taking on would save us. And that would actually bring the low estimate down for an enrollment inspection another $1,000, making the low average around $2,200 per inspection, instead of the current going rate of somewhere around $3,600 per inspection. And that would require, would not necessarily require board approval. It's not really in the rules. It's kind of a policy of ours, but I'm open to any sort of feedback from the board, obviously.
It would take more of your time.
Exactly. It's not free. So it's one of those things that's just going to have to be, modifying my workload in certain ways.
And those maps and stuff that you're having cut out are just standard.
Well, and actually,
it's not site specific, or
they are site specific. I actually brought one version that kind of shows, actually, I redacted it. But basically there are 5 different maps in there. One is an aerial survey map that basically just shows the location of the home. And then one is the shrink swell soils in that area. And they basically are ranging from low to high, and it'll show the potential effect of those shrink swell soils in this particular area based on the location of the home. So you can look at, is my home potentially being impacted by high ranged expansive soils? And that gives some proof to when, if Tetra Tech has determined that the majority of the damage in a home might be due to expansive soils or shrink swell soils in the area, it kind of lends some credence to that because it's basically mapped. In addition, there's a mine map that basically provides the location of the underground workings in association with the location of the home. There is one that is actually, it's kind of neat to look at. It's a Google Earth image. And I know if you can go back and Google Earth and look at some of the previous years. There's one that I just looked at from 1947. And it's this aerial image, and we map out the location of the home in relation to what the land looked like in 1947, for example. There's some that are a little older, but they're a little more grainy. But the 1947 one's pretty cool. And then the final one, I believe, is the location of the home in relation to additional mine workings in the area. So they're pretty detailed, but I've been working with the GIS for 30 years at this point. So it will take some time to do, but it's not the kind of thing that's going to be, that particular part won't be super cumbersome. So, but again, it's one of those things where we're shifting some job requirements for others. There's not more hours in the day, unfortunately. In addition, we're looking at some future actions to be able to reduce costs. And actually, I want to go back and let you know that if you'd like, I can provide the board with a redacted version of what an entire inspection report looks like. And I can put that either online or in the board packet. I've redacted all of the personal information and all the home photos and things. So that you can kind of have an idea of what that looks like. If you're interested, just let me know. For future actions that the MSPP is looking into to reduce some other costs, we're looking at contacting some non-engineering firms. And I think this was brought up at one of the previous presentations to try and solicit potential costs so that we can compare those costs for enrollment inspections to Tetra Tech's proposed lowered revised costs. So basically, these other firms wouldn't be engineering firms. And so now that we have a kind of a pared down cost from Tetra Tech of what a non-engineering impacted report and inspection would look like, we can kind of compare apples to apples with these other firms and get some cost estimates from them just to see if maybe they're any lower than Tetra Tech's in addition. So that might be able to save us some additional funds. These non-engineering firms that we contact would provide the program with viable lower cost alternatives for performing the initial home enrollment inspections. And then we'll compare those costs with the lower Tetra Tech estimated costs And the plan is to keep Tetra Tech as our contractor for the more rigorous claims and inspections and any subsurface investigations that are required. This data will actually allow us to potentially outsource those initial home inspections to one of these non-engineering firms eventually. Potentially, depending if they're low or not. And another future action that we're looking at taking is right now I'm working on gathering information to potentially conduct an actuarial study that would determine the feasibility and potential benefits of expanding some of the various requirements that are in the rules, such as adjusting the 1989 home construction date requirement or even eliminating it so that the program can legally include more homes. Increasing the cost of new home enrollment inspections for example, for selected severe or high hazard areas, or increasing the enrollment inspection fees across the board for all new homes, modifying the amount and or payment frequency of annual fees, making them basically more than the $35 that are paid only for the first 3 years currently after enrollment, and making them paid in perpetuity. That used to be the way that the program was run, is those fees were required up until I think 2002 to be paid annually throughout. And currently we've reverted to a $35 fee that's only paid for 3 years. And then potentially establishing appropriate guidance that's in regards to the maximum expenditure amounts for various inspection types. Any of these decisions that would modify any of the bulleted items that are on this slide that I just went over will require the board's and trustees' approval, and then rulemaking likely in most, if not all of those cases. But there hasn't been a revised actuarial study. The original one that was performed at the initiation of this program was done in 1985. And I think that was discussed at one of the previous board meetings as well, is how long it's been since we've actually got good data that we can kind of hang our hats on and say, this is going forward, parsing out these different variables. We would end up having a company that we could say, these guys did all their, all the vetting, all of the information gathering, and they basically distilled these different variables and said, yes, it would make sense to increase costs to the homeowners for various locations. Maybe it's more important to only include higher severe hazard risk areas and not so much the low or moderate. So it would be good to have that kind of data in hand to basically say, come to you as the board to say, here's what we recommend and here's the data to back it up. Any actuarial study obviously won't be inexpensive. So we've come back to the board and let you know when we have some proposals in hand so that you guys can approve or deny any sort of actuarial study expenditures. And another potential source of cost savings would be to modify the rule that requires all new enrollments that are not transferred into the program, that they require an additional new home enrollment inspection. So instead of, if a home had been enrolled previously, then an initial home inspection was performed. That original home inspection would then be used as the baseline for any claims that were made, rather than paying to conduct a new one simply because the home has changed hands and has a new owner. So that would end up saving us from having to do new home inspections for every single home that hasn't been transferred in terms of the enrollment. This is a process that we're just looking into because it will require additional legal review due to the potential implications to rules 8.02.2 and 8.02.3.
Along those lines, if there was an incident where there was subsidence and after the initial, wouldn't that require another baseline inspection?
At that point, if the homeowner made a claim, they would if they were enrolled, and they would say, we're enrolled, and we would use that original baseline inspection to compare the damage that we're seeing today versus what was seen at the original time of the original inspection. So it would potentially provide more damage repair for a home if the inspection was done 20 years ago versus 2 years ago. So we'd be comparing the current state of the home to the original inspection report, which may have been done 10, 15, sometimes 20 years ago. A lot of the homes that were initially enrolled have inspection reports that were done in 1990. Because that was the initial kind of thrust of the program where we were out there trying to get people enrolled. And so a lot of the home inspections were done late 1989 and then into the early 90s. So some of them are quite old in terms of the original inspection reports that were done. So there are definitely some implications that we need to work through in terms of the legal implications and then the implications to the rules themselves. So that one we're working through. And then this is that table that I think I've shown you almost at every one of these presentations. But this basically shows you that we're working on these two, 1A and 2B are the ones that I'm reporting out to you now to show you that we've made progress in terms of evaluating the potential for cost savings to the program with regard to our expenditures on contractors. And then in June, I will be back to discuss the highlighted yellow items. And then finally in December, I'll be back to discuss the final two. And I will likely be back here in January to do our annual report. So basically calendar year report for 2025 so that you have some idea of, again, the state of the program itself financially and then with regard to enrollments. And then if we have any updates on some of the reductions in expenditures to our contractors, I'll update you at that time as well. And then possibly between January and June, if there's movement in terms of expenditures for the actuarial study or any other things that come up along the way that we want to get board approval or report back to you on, it's possible I'll be back to see you somewhere between February and May before I'm back in June. And then I do want to call out that I wanted to make sure that you guys understood that we're actually looking at and addressing the previous board recommendations. And I think this was something that was brought up last time where on our MSPP website, it would be very helpful, and I completely concur, if we had kind of a pared down GIS where homeowners could type in their address, click a button, and it would zoom into the location of their home in which region or which hazard level area that their home might lie within. This is just an example, but the little turquoise dot, you can't really tell that there's an A on it, but the little turquoise dot that lies within the yellow low area is just an address that I grabbed so that you could kind of see how pinpointed we can get with some of the information where people can zoom in and really see, gosh, you know, is this really worth it for me to enroll in this program if I'm only in a low lying area, a low hazard, subsidence hazard risk area. And so I think this was a recommendation or a question that had come up at one of the previous board meetings. And I'm currently working with our IT staff to see if that's something that we can add, how we can add that to our website page so that that's more helpful to homeowners themselves too. And I told you this would be shorter, so what kinds of questions can I answer for you all? Then
I think I asked this last time. Just, it seems like there should be some kind of requirement for a realtor to let the purchaser know that they need to look at this website, for instance, or just they need to know that this is a hazard for them.
I agree with you. Unfortunately, that's more of a legislature sort of thing. But if you want me to stand next to you and shout at the legislators that needs to happen, I'm happy to do that. Quite good at that.
Seems like legislators especially in those areas would be for that.
Some of the state senators, potentially some of the representatives in certain areas, I think would be really good to petition to make that change. But that's also, I'm assuming that I need to remain impartial in certain cases, so I'm not sure if that's a place that I can go.
Madam Chair, this is Jeff Graves with the division. Just as a aside to kind of the concern you voiced regarding disclosure related to mine hazards. I mean, the program kind of under Deb's guidance and Rachel's guidance previously has done a lot of education for the realtors. And I think that is certainly an avenue we can pursue to ensure that realtors are educated in terms of the resources available to them to identify for potential home buyers or sellers what the risk is associated with mine subsidence. And I think that's probably the most we can do is that education component with respect to ensuring that buyers and sellers are aware of what those risks are in those areas.
Just seems weird to me because of buying and selling homes where there's an intensive inspection of all kinds of things that are minor compared to this. And it seems like this should show up.
Yes.
True.
Mr. Baker here, I'd like to see the date restriction removed. That to me is a very simple way to expand the program. And I don't see that there's a lot of exposure there. But that date is arbitrary to begin with. And just get rid of it, and then you can talk just about the geographic areas rather than the date restriction.
And Mr. Baker, that's definitely something that we're considering. I think as part of the actuarial study, that'll give us a good handle on what the implications are for the trust as a whole. Obviously, removing that date certainly increases the liability associated with the trust and what it would have to cover. And so just ensuring what that would look like in terms of sustainability for the trust, because that's obviously a big aspect of managing those trust funds as the board is the fiduciary, has that fiduciary responsibility for managing those. I think we just want to make sure that we have a good handle on what the implications are associated with modifying things like rules related to cutoff dates and including additional homes in that. But I think that's absolutely something we're evaluating as part of that process and want to be able to provide you guys with the information to allow you to make an informed decision on changing some of those rules that have bigger implications.
And that's one of the reasons that we're looking at doing that actuarial study is to basically be able to collect and provide them, like use real data and collect and provide that data so that we can really have something that's as concrete as we can get to say, yes, this is the way we should be moving forward. Because those actuarial studies can look at those different variables and how they would affect one another. And then we can come back to you and say, here are the facts that we found. But that's definitely something we're considering for sure.
I just think expanding the program to meet the needs of the homeowners in those geographic areas, you know, if yes, you would expose yourself to more liability, but you'd also expose yourself to more revenue coming in. And you know, the purpose of the fund was to compensate homeowners that might incur some damage from a previous coal mine. But in the past few years, we're sending out more money with consultants than we are with homeowners. So I think we just need to look at expanding it and making it more viable to the residents.
We would agree. I mean, that's part of our evaluation.
Absolutely.
I have a question around the initial inspections. If you use an alternative to Tetra Tech, what would the qualifications? You said non-engineering companies, especially with the expansive soils being so pervasive in the same areas as the coal mines.
Right, in looking at the inspection report, we actually have this form that we asked Tetra Tech to develop, for us that we own. And so we have this form that we would end up providing, has very clear, criteria, has very clear descriptions of what damage is, the criteria of each potential kind of damage. And the majority of those do not get into the shrink swell soils. A lot of it will look at drainage in and around the homes, from the gutters and from the downspouts. If they're draining directly next to the home, generally that's not the best thing. You kind of want to get the water as far away from your home as possible in general, for most of us anyway. So those are the kinds of criteria that they'd be looking at. Technically, the inspections themselves for the home inspection, the initial enrollment inspections, it's my opinion that they could be under guidance and direct inspection of the inspections. Like I would stand there with them for at least whichever company, if we ended up picking one, I would go with them and make sure that they're abiding by and collecting all of the pertinent data. But as far as the shrink swell soils information, that's generally something I would end up providing in part of the cover letter and then in the maps that we're providing as well. So that's usually, that level of detail isn't necessarily something that a home inspector, for example, obviously we want a company that can kind of show up on a week's notice. It'll be a lot of flexibility in terms of scheduling. We need to know that they'd be available kind of at the drop of a hat for us if we needed it. But it's those claim inspections that are really kind of the more rigorous types of inspections that we would require the engineering firm to take care of for us.
So you have some timeliness qualifications and stuff, but what other qualifications? Because I mean, are they home inspector types, or I mean, that's it's a wide pool. You could.
Right, absolutely. And that's a great question that we're going to kind of work through in terms of what those criteria would be. And it would be baseline criteria for whoever would want to participate and basically be our contractor for this. And right now we're just soliciting cost estimates, and based on, in my opinion, based on the responsiveness of companies to those estimates, their capacity to work with us, their preclusion to being able to, as I said, show up, kind of have a flexible schedule, show up when we need them to show up and not say it's going to be 3 weeks before we're able to get out there. Those would end up being some of the most important criteria. And then I believe if we look at certain reviews and then look at their Secretary of State standing on the Secretary of State's company's website, make sure they're in good standing. And then I'm a big fan of looking at reviews from different people, and especially homeowners. But there will be a very set level of criteria that we'll be using for anybody that we ended up hiring. So right now we're kind of just at the stage where we're soliciting general estimates for what they would charge to fill out this form and perform the inspection and take these photos and look at these different criteria. So
I think we put some pre-qualifications in place to ensure that we had contractors that were both experienced, understood the expectations associated with the inspection, and likely could go through some type of scenario with those contractors to ensure that they're capable of documenting the things that we need documented. But kind of coming back to what Deb had mentioned, those pre-enrollment inspections, even in the audit findings, the auditor identified those as a potential area where engineering services might not be necessary. And so I think that's part of our process, is evaluating those initial enrollment inspections, recognizing it's really photographing. You're taking a camera into someone's home and documenting existing damage. So you need to have the understanding of where to look for damage, I think is kind of a pre-qualification, understanding of how damage typically occurs in a home, but really it's just documentation. And so the auditor kind of singled in on that as not maybe requiring those higher level engineering services, and thereby being able to save some costs. But then as Deb indicated, those claim inspections are really where you're looking for the engineering expertise to be able to discern what the mechanism is behind damage that's been observed. So
That's quite clever. To get someone who photographs everything versus, yeah. That may be the important.
so we'll see.
Yeah.
Interesting.
And again, if that ends up, we end up going down that route and ends up not being the level of detail for whatever reason that we need, then we can discuss from there. Things need to.
Sure. And I think, as Deb mentioned, we've already put some mechanisms in place to save costs on those initial enrollment inspections. So I think we feel like we have at least addressed some of those concerns mentioned in the original audit findings for 2B item. And so I think whether we end up utilizing some other type of non-engineering service to conduct those initial enrollment inspections, at least we've attempted to reduce some of those costs associated with that. So I think we feel comfortable that we've at least exhausted the potential options. But since the auditor did recommend at least evaluating non-engineering services, that's what we're doing.
Gotcha. Thank you.
I have a quick question. Well, first of all, I'd like to thank you for addressing the previous mapping recommendations. It looks like you're making great progress, and that's great. My question is, when you talk about high and severe subsidence risk areas, how is that defined? Is it an objective measure? Is it a model-based measure? Or is it just, we kind of think this is high versus not high?
Those were based on, at least in Colorado Springs area, is based on one of the original surveys that was done in that area, I believe in 1985. The Dames and Moore did a study themselves and provided that information. I'm wondering if I can go back to, if you wanted to see that slide again, but basically they provided working maps of various areas that have been geo-referenced, so that now we've got GIS layers that we can overlay on top of the aerial maps and home locations. Before, whereas they were paper maps, obviously in 1985, but those have been geo-referenced so that we can then be able to provide that information, that level of detail on our website on that GIS. But that was done back in 1985.
And Mr. Orr and I can speak a little bit. I believe they did utilize a model to evaluate the risk associated with subsidence, and it incorporated occurrence. And so they evaluated time since mining stopped versus occurrences and utilized historic aerial imagery to compare time periods of when they noticed subsidence at the surface versus when mining stopped, and then also incorporated depth to mine, overburden material. And so the model was somewhat complicated in terms of incorporating all those geographic specific information, geologic specific information to develop risk criteria and then categorize those based on that potential risk. But it does incorporate the likelihood of occurrence. And that was done through some evaluation of historic aerial photography.
Okay, thanks.
Any other questions? Thank you all so much.
Good report.
Appreciate your time.
Madam Chair, if I might, your lunch is sitting there at the back. If you would like to take maybe a 15-minute break to grab your lunch and stuff, we could do a working lunch and I'll do my presentation while you eat. And then that way we can go into executive session and stuff. And maybe we can save a half an hour or so and stuff there. Is that a good plan?
Sounds good.
Okay, all right.
Madam Chair, just from a time check, or the executive session is just an update, not a need for a quorum, correct?
Well, to go into executive session, we will need.
Right, which I feel like we
supermajority.
have.
Yeah.
Okay.
We don't have a vote afterward. We won't be asking for action during, coming out of the executive session, but we'll just need the supermajority to go into it.
Just doing a time check since this is on my calendar until 1, and if we do a lunch and another update and then another executive session, we probably are gonna go past one.
Do you want to do the executive session and then I can finish out?
Yeah,
I don't want to mess with lunch, just doing a time check. I just kind of I wouldn't
Yeah.
call it a hard stop at 1, but I'd call it a ish.
Yeah.
yeah, and no,
1:30.
if it's fine with you, Karen, as the chair, we could swap the executive session with the rulemaking update from staff. I'm happy to do that. Like, so I mean, we can still do that over lunch. You know, come back in 15 minutes, go through the process to get into executive session, and then give you an update while you eat.
And now you've gone through rulemaking before and stuff, so I don't think I'm gonna be presenting anything that's stuff that you're not aware of and stuff anyway, so.
Yeah, I'll stick around as long as I can. I just didn't want to mess up anything if I had to leave.
Appreciate it.
Okay, but eat your lunch. That's important. Cammy always does such a nice job. We don't want to mess with that.
Okay, so we'll go grab lunch and then do executive session.
Yeah, come back at 25 after.
25. Sounds good.
Good, I can eat lunch too.
Since Cammy told us it was holiday.
Here you go. Anything else for me? I don't think so. Karen, this may be a world landscape record for us, but this is her on forfeiture. We just kind of given the deadlines, I kind of preloaded some stuff and was able to build it. Tammy's gonna be gone towards the end of the month, and with all the like.
Change that to the 7th.
Thank you, sir.
Still on.
That was fine, but obviously.
Just realized I never did ask for public comment, but we didn't have any public, so. Hey, we have people on. Okay, we're going to come back into order with our lunch in front of us. And I'm going to make a motion to enter executive session. I move that the board enter into executive session for the purpose of discussing with counsel disputes that are the subject of pending or imminent court action, discussing specific claims or grievances, receiving legal advice on specific legal questions, and discussing matters required to be kept confidential pursuant to CRS section 24-6-402, parens 3, parens A, parens 2. I have to read down that, including judicial review case Rocky Flats et al. Versus Colorado Mineland Reclamation Board and Colorado Division of Reclamation Mining Safety, Denver District Court case number 2022 CB 32904. Do I have a second?
Okay.
Okay, we have a motion and a second.